Hi, it's Dre Griggs of the Obsidian Wisdom. Today we'll discuss the 8 worst estate planning blunders and how you can protect your assets for your future generations. When it comes to our death, most of us don't want to talk about it, and that's okay. But it's important to make sure that all the work that we've done to generate the income, to build the assets, to make sure that we have a comfortable retirement, that if we want to make sure our family is protected and our kids and our spouse, or even causes that we believe in, that we have to have a solid estate plan in place. Estate planning is just the wealth transfer. How are you going to transfer your wealth? Today I'll discuss the 8 worst estate planning mistakes that I see. The first one is that you're stuck in probate. And that just means you don't have a will or anything set in place. As a result, you have to trust the good old government to decide what you want it to do with your stuff. Now, we all like to think that our family is going to be very nice and understanding and considerate of each other. But if you look at the way the estate process works, if you don't have a will, your family is going to get kind of nasty. And it's not that any one person or all of them are. It's just one of those things where if you feel like you're getting the short end of the stick, you're going to defend yourself. And how do you defend yourself in a probate court? Well, most people are going to defend themselves by saying how great, they were. Like, I took care of my dad. I watered my mom's plants. I picked them up and took them to doctor's appointments. They always wanted me to be the one to make the decisions. Well, if that's what one person is saying, what's the other person going to say? Well, they have to say, well, that's not true. This person hadn't talked to mom and dad in 15 years, and mom and dad knew that they were, knuckleheads with money and things like that. Well, you have to convince this judge. Now, granted, I would love it to be where people who did have to go to probate courts where they were able to just say, you know what, I did this, this, and this. And the other person said, well, I did this, this, and that. And then we just see what the judge ultimately decides. Or they meet separately and then they kind of work it out and they figure it out themselves from there. But the reality is, once you get in court, you just get a little, I don't even know what the word I'm looking for, but it just gets nasty very quickly. If you could talk to anyone who's been through the estate planning process that knows anyone, either they're the sibling and their parents passed, or they retired and a friend passed, and you will find that if there's not a will in place, that things can get kind of dicey either between the kids or even between spouses if you had multiple marriages where one spouse is saying this and the other spouse is saying that. No, you just want to make sure you have a will in place. And unfortunately, a lot of us think we don't have enough assets for a will. But the truth is, you should always have a will in place. It doesn't really cost a whole lot to do it. And it will ensure that your family stays connected, which is going to be probably the most important thing about most of us when we're building wealth for our family, is to make sure our family still loves each other and they're still working together, that they're not splitting the assets and diluting our abilities where they're saying, well, I don't want to keep this property anymore with that family member, so we have to sell it, right? We don't want to have to do any of that. So the more things you have already predetermined, had discussions, then it just puts you in a really good place. The second one is ignoring the lifetime gift transfers. Now, in 2023, it's $17,000 per year that each of you are allowed to give. So you and your spouse to each person. So you can give $17,000 to one kid, you can give $17,000 to a friend, you can give $17,000 to different family members, and you can give out this $17,000 each year per person. And every time you do that, that is a little bit less that you have to have them paying in taxes. And some people will say that it makes sense for them to give larger assets early on, but we're just going to focus on the free gift amounts. As a result, you can give that amount each year. So if you said, you know what, I'm looking, and Dre said that currently, and let me see what it is. I believe it's like 12.9 million. So we'll just say 13 million to make both of our lives easier. So you're allowed to transfer $13 million in your estate without it being taxed with the death tax, which we generally is the estate tax, where it's about half of your assets end up getting taxed, right? Just rough numbers to make it easy for us. If you were at 14 million, and you were able to put a plan in place where you were able to give $17,000, and it's been increasing. So like last year it was 16,000, like 500 or something like that. But you're able to give $17,000 each year to your kids. Well, you're going to be able to make sure that you're limiting the taxes and you're giving in the most efficient manner. And I think it's personally one of those really good things, because ultimately what happens is you're able to see what your heirs and the nonprofits and the different places that you have supported, what they do with the money. And I think that that's a beautiful thing, because it's one thing, obviously, it's great to be able to say, I'm going to be giving you, millions of dollars when I pass. I mean, who wouldn't accept that? But you don't get to see what they do with it. You don't get to see them paying for college tuition, paying for a wedding, or starting, buying a house, a down payment for their house, or starting a company of some kind. Like, you don't get to see that, and they don't get to properly thank you because you're already gone. So I do think that it's really good to be able to take advantage of some of those lifetime gift transfers. Number 3, we have not meeting the liquidity needs. And if all of your money is in certain assets, so I always encourage you guys, right? 65% of millionaires have at least 3 streams of income. And so if you look at the main 3 assets, that's going to be a business, that's going to be the stock market, and that's going to be real estate. So if those are the 3 main streams, well, those are kind of hard to liquidate, where it's not going to be very easy once you pass for your spouse to be able to pay the different taxes, to be able to pay for the funeral expenses and these different things, because the money is going to be tied up. They need the death certificate, and they have to go through their processing, and they may want the will. And then you got to make sure that no one's saying, well, that's not the right will, I have a different will, where the money may be tied up. And as a result, if you don't meet the liquidity needs, how are they going to pay for these things? Will they have to take out loans to do it? Will they have to sell some things that they don't want to have to sell and they wouldn't sell if they weren't in a bind? So it's important that you just make sure that there's some amount of liquid cash that's set aside, or at least you have the ability to access something where it doesn't have a very negative impact. Where the stock market, if we're in a recession, you selling then may be locking in significant losses. You don't want to sell that. Real estate could be the same thing, or it could take a time for you to be able to find the buyer for the market price. But if you sold it below market price, then you could sell it quickly. You don't want to have someone making these tough decisions or taking out a loan in the business's name or different things, because once someone passes, it's really hard for us to be able to kind of pull it all together to make whatever the financial decision, the right decision that we need to make, because we're just not thinking very clearly. And so if you have the liquidity amount set aside, whether that's 10, 15, 20,000, 30,000, whatever that is, you want to make sure that that is somewhere accessible for your spouse so that they're able to take care of it. If you're finding value in this, if you're someone like me where I'll watch or listen to videos, then I have already set up where you can download a PDF. It's almost like a little ebook where it's just going to go over the 8 bullet points. It's more like a guidebook. If you go to obsidianwisdom.com/estate blunders, then you can be able to put your email address and you can download the 8 most common mistakes that people make in estate planning, and then you don't have to write everything down. Now, if you're writing it down and you don't need it, that's great. Don't even worry about it. But if you would find value in that, then you can go ahead and get it. And we'll keep going. Number 4 is just chaos regarding your children. Ideally, when we pass, our children are grown and they're kind of able to take care of themselves. But if for some reason we pass and our children aren't 18, where are they going to go? Who's going to take care of them? Does that person know that they're going to take care of them? Have we put a list together of their favorite foods and the favorite places they like to go? Where they have their best tendencies as far as their friends and studying and different things? Have you written all this stuff out? Have you talked to that person? Do they know that you're thinking of them when you say, if something happens to me, who's going to take care of my kids? And do your kids know? Have you set these things aside so that your kids are able to have as seamless of a transition as possible? This is also important because your children, if they're under 18, they're not able to enter into a, quote, legally binding contract, right? That makes sense. If your kids go to school, then you would sign the permission slip. Why is that? Because your kids can't sign it themselves, because they can't enter into like a legally binding contract where they're saying, you know what, I'm okay going on this field trip and I promise not to sue you if something happens. Right? Kids can't do that. The U.S. government feels the same way when it comes to inheriting assets. You cannot transfer your wealth to your children under the age of 18. You shouldn't have your kids as the beneficiary on your retirement account. You shouldn't have your kids as your beneficiary on your insurance claims and really anything, because your kids aren't old enough to access that money. As a result, it gets sent to the state and the state hold it till the kids turn 18, but that's probably not what you wanted to happen. So it would be a better situation for you to have someone who's going to take care of your kids, and then that person has some sort of a contract, whether you have it set up in a trust that helps to make sure that the money is being used in the proper ways. But you need someone who's over the age of 18 who can access the money so that your kids can then have access to the money who are under 18. Now, when your kids are over 18, your job as a parent is to make sure that you keep the family together. You don't want your kids splitting over the assets. You don't want them not talking to each other, having arguments, saying evil and awful things, feeling like they're being taken advantage of. And so you want to be as open in the communication as possible so that your kids are well aware of your intentions. And you do everything you can to make it as easy as possible for the judge to say, this is what, Dre and Yams wanted to do for their kids. And so I'm going to, do my best to just stick to what Dre and Yams decided. Now, if you don't have that, again, then the judge is the one that's going to be listening to these arguments and then deciding how to split the assets up. And you may have a good judge that completely gets it right, and you may have a judge that gets it completely wrong. But your instruction as a parent, it doesn't end when you pass. You have to continue instructing, making sure that your family understands the values. And the best way to do that is to make sure that you already have these instructions written in the will and set aside, and that you have the open communication necessary. So fifth on our list, we have no incapacity plan in place. When you look at incapacity planning, that means that we're slowly starting to lose our mental faculties. And the way I describe it to people, it's not that the person has this cliff that they just fall off of, but it's that it becomes slightly more difficult for them to process information, where they used to be able to very quickly say things, remember things, and understand things, to where maybe they need to hear it 2, 3, 4 times. They need to repeat it to themselves and out loud maybe a couple times, and then they eventually come to the same conclusion they always did. But as you notice that things become slightly more difficult to process, sometimes that will open up for them to be taken advantage of, where maybe they have a whole bunch of accounts that are open, where this very nice person was able to set them up for all these different subscriptions, but your parents have no idea that these accounts were open. They don't notice that the money is going out to pay these bills each month, and they are sort of being taken advantage of, even though they feel like they wanted to do that. You want to look at incapacity planning as just that slow progression, but you need to have the decision made while everybody is in their right mind and the right faculties, to where you say, look, if something, if ABC happens, if we have these 3 events happen, then we're going to go into our incapacity plan. Now, sometimes you don't have as much of a notice where you can see a slow decline, and then you can discuss it with other family members. Hey, are you seeing the same thing that I'm seeing? Oh, I didn't notice, but I'll look next time. And then you meet a couple weeks later, and you're like, oh yeah, I know what you're talking about. I think everything's okay. Or no, I didn't really see it, but then, I'm going to look again. Where you have a little bit of time to put something in place, but you already have the incapacity plan. You're just deciding whether or not you're going to enact it. Now, the other one is the quicker one, where someone maybe gets Alzheimer's or dementia, and then the decline happens very quickly. You still want to have the incapacity plan already set, and then you simply are like, okay, let's go to this plan. Now, when it comes to an incapacity plan, there's different documents, and I'll go over each of them for you. So one of them is the power of attorney, and that's the one that most people are familiar with. That's where you have the financial and legal decisions made for someone. The next one is an enduring power of attorney, which is nice because that one is specifically designed for when someone is mentally or physically incapacitated. A representative agreement is the right that we give someone to make our healthcare decisions. If you have a representative agreement in place, the doctor's not even allowed to make any decisions without you knowing ahead of time. And so that one's pretty nice if you want to make sure that you have the healthcare decisions that are going to be set up. And then the last document is called the Advance Directive. And all that does is it lays out all of your beliefs about healthcare, how you want your care given to you, how do you feel about different things, whether you think this is good or that's not bad, what you want and don't want in your body. And as a result of having an advance directive, the doctor and your representative would both have to honor that agreement. So it's actually very nice, to where maybe if you have slightly different feelings on something, that it's like this is what trumps all. And if you have those 4 documents in place, then you're ready. You have your incapacity plan in place, and then people don't have to try to figure out, well, does dad want to be resuscitated, or what are the bills that I can pay on his behalf, and what should I be canceling? Where you have these discussions early on and you have the plan in place. It's just a really good document, and most people overlook having an incapacity plan in place, and as a result it becomes very ugly and difficult for them to be able to cancel certain contracts that their parents maybe or maybe didn't go into. The 6th one we have is just leaving your spouse in a bad place. In 2021, American women lived to the age of 79, that's on average, and American men lived to the age of 73 on average. Now, right, some people live longer, some people live shorter, but that's the average, right? The average, and you can expect, is that women are going to live longer than men. So what do we do to make sure that our spouse is taken care of? Well, we talked a little bit earlier where you want to make sure that you have things like the funeral expenses, the estate taxes, and other bills ready for them to be able to have some sort of liquid assets to be able to pay those bills. It's important to know that your power of attorney is no good when you're dead. So you want to add your spouse's name to the documents when possible. Naturally, if they're just the beneficiary of something like your retirement account, your 401k, your life insurance, those have the ability to write in a beneficiary, well, then you're okay. They're going to be able to get the assets given directly to them because it is them written as the beneficiary. But the rest of the documents where you thought you had a power of attorney and you were going to be able to take the money out of the account, that is not how that works. That right? If we're passed, then we're not allowed to give the rights to make decisions for us because we're dead. So you can't do it that way. But you'll be surprised at how many times that comes up where people are like, dang, all the money is in my spouse account. We always pay these bills from the spouse account. And then they'll be like, all right, I think I'm going to try to just pay the bills, for the next couple months to just until I can figure out what to do with this. But you don't want to be stuck in that spot where you're like, I hope that nobody finds out through the death certificate, and then they close the account and it has all this money and it takes a while for me to get it. And so you don't want to leave your spouse in a bad place either. Number 7 is you have the charities. There are some charities, some smaller charities, that you are the main donor. You're like, when you're gone, the charity might not make it. And if whether it's a church or a synagogue or a mosque or wherever you worship at, if it is a nonprofit that you visit and you give of your time and you give of your means, maybe you're like their number 1 donor for their gala or their run of some kind, their 5K. So you just want to make sure that those nonprofits are taken care of. Now, there are a variety of ways for you to accomplish this goal. There are different trusts that you can set up, but you could just list them in the will where like, hey, I want to give this amount to, A, B, C nonprofit, right? Just whatever you want to do. I just want to make sure that you're aware of it, that you're thinking of them as well. Now, before we go on to our 8th and final blunder, if you're finding value in this, I ask you to like and subscribe so you can keep getting valuable retirement planning and family wealth generating information from me. If you're enjoying this and you want your own guidebook on estate planning, you can go to obsidianwisdom.com/estate blunders. Our 8th and final estate planning blunder is inefficient and ineffective transfer strategies. So there's generally 2 ways that you can transfer your assets. Number 1 is you transfer it at your death. Number 2 is you transfer it while you're alive. You want to find the most tax efficient way for you to be able to transfer your assets. Now, currently in 2023, you're allowed to transfer up to $12.92 million without having to pay the estate or death tax, right? So you're able to do that. You're able to transfer up to $17,000 per year without having to pay any sort of a gift tax. You're able to put a plan in place to make sure that your stuff isn't sitting in limbo like some estates that you read about for years and decades, or people are paying lawyers the significant amount of the estate because they're fighting over it. I think Anna Nicole Smith was one of those where when she had passed, she didn't have anything in place and they were fighting for decades. I mean, decades. It's like crazy where people fight over all of these estates and it just gets very ugly very quickly. Ideally, you want to be able to just do a couple things. One is you'll say, okay, if our retirement accounts, let's say, is going to be, I don't know, $100,000, $1 million, if my child has to take that amount, it's going to put them in the highest tax bracket because they'll have to claim it as income. And they're not given as much time to transfer those assets each year as like my spouse is. My spouse is given significantly more time than the rest of my children would be given. If I want to make sure my kids aren't going to have to pay a heavy amount in taxes because I didn't do all this work for Uncle Sam to get all the money, then you may want to have a plan in place where you're able to transfer some of those assets over early. Another benefit of transferring assets early is if an asset appreciates. And so if you have a house, and let's say you have a house for, I don't know, it's worth like $100,000 to make math easier for me, and you were able to transfer it to your kid today, well, then they would pay taxes on, whatever, the $100,000 minus whatever the gift is, if you haven't hit the gift. Well, if you transfer it at your death in 30 years, well, that $100,000 house now might be worth like $700,000. And now because the house is worth $700,000, when you transfer it to your kids, they're going to pay taxes on $700,000. But if you transferred it earlier, then they would have only had to pay taxes on, like a seventh of that. And so anytime you have appreciating assets, if you're positive that you're going to give it to a certain child, then it would make sense to try to do that a little bit earlier. Naturally, there's lots of things that has to go into that decision for you to understand that makes sense for you. I'm just talking about one sliver of it. So, right, don't just go and do it because you said, oh, Dre said it on a video. Each of us have such unique situations that I would have to talk to you one-on-one to genuinely be able to say this makes the most sense for your particular situation. But what I am saying is if you're concerned about transferring an asset and them paying a significant amount in taxes, and it's an appreciating asset, you should at least consider transferring it to them earlier, paying the taxes on a smaller amount, and then it appreciates with them. And so now they're not paying the same taxes that they would have paid if it appreciated with you and then transferred it over. This also helps for you on the estate side because you can't go over that 12.9, so I just say 13 million. Because you can't go over that, if you have this house and you have a bunch of them, and each of the houses are appreciating to over $1 million, well, now you're going to be hit with the death tax, where half of your estate is going to be taxed. But if you had transferred it earlier to them, and it has to be at least 3 years earlier, right? So Uncle Sam's not a fool. He's not going to sit there and be like, oh, okay, you transferred it like on your deathbed, so now your estate's not going to be taxed. No, like it has to have been done 3 years earlier for it not to count on your estate. So if you transferred it early enough, so now it doesn't count on your estate, well, now you're below that threshold and you don't have to worry about that tax. And because you transferred it early enough, the appreciation hadn't happened. So you're also not bumping up against that $13 million limit versus if you have all of your assets appreciate and now they're worth, $100 million. Well, now you have this huge estate tax to pay. Now, I mean, that's part of the reason why you end up finding a lot of people do end up donating, where charity is a big thing for very wealthy and rich people, because if you could choose to give it to a cause you believe in and want to support, or giving it to Uncle Sam in taxes, most people would want to give it to a cause that they support. And I think that that's pretty fantastic as well.